Good day, ladies and gentlemen, and welcome to the maiden edition of this channel, The Joy of Law, where you discover the joy of law. Oh, the thrill of studying the law. It's like a breathtaking roller coaster ride, and I can't wait to share it with you, fellow law students and students of life. So today I've decided to start with the doctrines and principles in corporation law, which is one of my favorite subjects in law school. The list is by no means extensive, but I thought that these are the most important ones, important doctrines and principles, as well as concepts that one should have and should learn by heart if one is to go through corporation law. So let's get on with it. The first doctrine is the doctrine of corporate entity, where it says that a corporation is invested by law with a personality distinct and separate from its stockholders or members. In the same vein, a corporation by legal fiction and convenience is an entity shielded by a protective mantle and imbued by law with a character alien to the person comprising it. This is according to the jurisprudence laid down in the case of Lim versus Court of Appeals. The second doctrine is the doctrine of separate juridical personality. A corporation is a distinct legal entity to be considered as separate and apart from the individual stockholders or members who compose it, and is not affected by the personal rights, obligations, and transactions of its stockholders or members, according to the case of Sulo ng Bayan Incorporated v. Araneta Incorporated. Now, the third doctrine is one of the more popular ones. You are going to hear this over and over in corporation law classes. So it's a doctrine of piercing the veil of corporate entity, and which is an exception to the doctrine of corporate entity, to the first two. Under this doctrine, where the fiction of the corporate entity is being sued or rather used as a cloak for fraud or illegality, or to defeat public convenience, justify wrong, protect fraud, or defend crime, or for ends subversive of the policy and purpose behind its creation, this fiction will be disregarded and the individuals comprising it will be treated as identical. Liability here will attach personally or directly to the shareholders or officers, or where there are two corporations, they will be merged as one, and the one being merely regarded as the instrumentality, agency, conduit, or adjunct of the other. So here a corporation will be looked upon as a legal entity as a general rule, and until sufficient reason to the contrary appears. But when the notion of legal entity is used to defeat public convenience, justify wrong, remember these phrases, protect fraud, or defend crime, the law will regard the corporation as an association of persons. Now, the fourth is the principle of limited liability, which is related to the first three that came before this. So under this principle, a corporate officer or a stockholder, as a general rule, is not personally held liable for corporate debts. And this is because we have discussed already, a corporation has a separate and distinct personality. It may incur its own liabilities and is responsible for the payment of its debts. If you want to read more about the principle of limited liability, you may want to check out the case of Zomer Development Company Incorporated v. Special 20th Division of the Court of Appeal, Cebu City. That's GR number 194461, January 7, 2020. Now, the fifth doctrine is the doctrine of business enterprise transfers. A corporation which purchases or takes over the entire business enterprise of another corporation or entity becomes liable for debts pertaining to such business enterprise. Likewise, the mere change of the medium of holding the same business, that is, from a partnership or corporation enterprise, would authorize piercing to enforce the obligation incurred. The sixth is the doctrine of estoppel, or corporation by estoppel. This is one of the more important ones, I guess. Among all, I think this would be the most popular, because you don't encounter this only in corporation law. You also encounter this in partnership, agency, trust, and in many other subjects of the law. So here, there is corporation by estoppel when a group of persons assumes to be, or rather to act as a corporation, knowing it to be without authority to do so, and enters into a transaction with a third person on the strength of such appearance. It cannot be permitted then to deny its existence in an action under said transaction. So, what is the effect of estoppel? When any such ostensible corporation is sued on any transaction entered by it as a corporation, or on any tort committed by it as such corporation, it shall not be allowed to use the ostensible corporation as such, cannot resist performance thereof, on the ground that there was in fact no corporation. So, likewise, a party is also stopped to challenge the personality of a foreign corporation and its standing to sue in the Philippines, even when it does not have license to do business in the country, after having acknowledged the same by entering into a contract with it. One who has dealt with a foreign corporation as a corporate entity is stopped from denying its corporate existence and capacity. And under the law of estoppel, those acting on behalf of the corporation and those who benefited from it, knowing it to be without valid existence, are held liable as general partners. And this is according to Section 21 of the Revised Corporation Code, if you want to check it out. Now, the seventh doctrine is the doctrine of apparent authority. Apparent authority is determined by the acts of the principal and not by the acts of the agent. As applied to corporations, the doctrine of apparent authority provides that if a corporation knowingly permits one of its officers or any other agent to act within the scope of an apparent authority and holds him out to the public as having the power to do those acts, the corporation then will, as against anyone who has in good faith dealt with it through such agent, be stopped from denying the agent's authority. This is laid down in the case of Soler v. Court of Appeals. That's on May 21, 2001. So the next is the instrumentality rule or alter ego doctrine, which is still related to piercing the corporate veil, where one corporation is so organized and controlled and its affairs are conducted so that it is, in fact, a mere instrumentality or adjunct of the other, the fiction of the corporate entity of the instrumentality may be disregarded. Number 9 is the doctrine of corporate opportunity. A rule by the Corporation Code making a director account to his corporation gains and profits from any transaction entered into by him or another competing corporation or entity where he has a substantial interest, which could have been a transaction undertaken by the corporation and which could have benefited the corporation. So this doctrine figured in one of our exams in corporation law. So the next doctrine that we have number 10 is the trust fund doctrine. This is one of the more popular ones. Again, you will often hear about trust fund doctrine in many parts of corporation law. So this doctrine states that the capital stock, property, and other assets of a corporation are regarded as equity in trust for the payment of corporate creditors. The subscription to the capital of a corporation constitute a fund to which creditors have a right to look for satisfaction of their claims. It considers this subscribed capital and property and assets as a trust fund for the payment of the debts of the corporation. Now, I think the exception to the trust fund doctrine is wasting assets corporation. So you'll have to look it up, but it refers to oil exploration companies and one that, etc., can distribute capital as dividends to investors. This trust fund doctrine also holds that the assets of the corporation, as represented by its capital stocks, are trust funds to be maintained unimpaired and to be used to pay corporate creditors, in the sense that there can be no distribution of such assets among the stockholders without provision being first made for the payment of corporate debts, and any such disposition of it is going to be considered as fraud on the creditors of the corporation who extend credit to the corporation on the faith of its outstanding capital stock, and therefore void. Okay, so that's the trust fund doctrine. The next doctrine is the doctrine of secondary meaning. This one finds its application when a corporation applies for its corporate name. So this basically just says that a word or phrase originally incapable of exclusive appropriation with reference to an article on the market, because geographically or otherwise descriptive, might nevertheless have been used so long and so exclusively by one producer with reference to his article that in that trade and to that branch of the purchasing public, the word or phrase has come to mean that the article was his product. So do watch out for this doctrine when you get to discussing how corporations get their corporate names. Now, the next one is what we call the holdover principle, which says that upon failure of a quorum at any meeting of the stockholders or members called for an election, the directorate naturally holds over and continues to function until another directorate is chosen and qualified. This seems pretty self-explanatory, so I'll go to the next one, which is our 13th, the theory of general capacity. This says that a corporation can perform such acts as long as it is not prohibited by general law and not contrary to morals and public policy. You will find basis for this theory in Section 2 and Section 44 of the Revised Corporation Code. In one of the cases, Montelibano v. Bacolod Murcia Milling Company Incorporated, GR number L15092, it said that a corporation is empowered to exercise any act which is not in direct and immediate furtherance of its business, fairly incident to the express powers, and reasonably necessary to their exercise, even if said power is not expressly granted in the Corporation Code. On to our 14th, which is the delegation theory. Under this theory, the directors are the officers and agents of the corporation, representing the interests of that legal entity and of those who own shares of stock. And as such, they can bind the corporation provided that they act within the scope of their authority. In other words, according to People's Air Cargo v. Court of Appeals 297-170, The board of directors may authorize and delegate some of its functions and powers to its officers, committees, or agents. And the authority of such agents may be derived from law, corporate bylaws, or authorization from the board, either expressly or impliedly, by habit, custom, or acquiescence in the general course of business. The next doctrine is the consent doctrine. This is an exception to the rule that a corporation cannot operate beyond the bounds of the state or sovereignty by which it is created or incorporated and organized. It says that with the consent of the foreign state, the corporation may not be prevented from acting in another state with the latter's express or implied consent. However, a corporation can exercise none of the functions and privileges conferred by its charter in another state or country except by the committee and consent of such state or country. The next one is the business judgment principle, which is again one of the more important ones. This says that questions of policy or of management are left solely to the honest decisions of officers and directors of a corporation, and so long as they act in good faith, their orders are not reviewable by the courts. From this, we may derive two branches of the business judgment rule. One is the immunity for decisions made in good faith, and the other is the one beyond judicial review. The first one, immunity for decisions made in good faith. There is a presumption that in making business decisions, not involving direct self-interest, corporate directors act on an informal basis in good faith and in an honest belief that their actions are in the corporation's best interest. The second one is beyond judicial review. Courts here cannot undertake to control the discretion of the board of directors about administrative matters as to which they have legitimate power of action, and contracts intra vires entered into by the board of directors are binding upon the corporations, and courts will not interfere unless such contracts are unconscionable and oppressive as to amount to a wanton destruction of the rights of the minority. This is according to the case of Gamboa versus Victoriano. Number 17. We are on our 17th doctrine now. This is the doctrine of relation. Under the doctrine of relation, which has been applied in many American decisions, where the delay in effecting the amendment is due to the neglect of the officer with whom the application is required to be filed or to a wrongful refusal on his part to receive it, the same will be treated as having been filed before the expiry date. This doctrine, however, does not apply where the delay is attributable to the corporation. This is according to an SEC opinion dated May 14, 1987. The occurrence of a fortuitous event or force majeure is considered a meritorious reason by the SEC to justify the doctrine. And the test applied by the SEC is whether, under the particular circumstances, there was such an insuperable interference occurring without the corporation's intervention as could not have been prevented by prudence or diligence or care. However, since the privilege of extension is purely statutory, all of the statutory conditions precedent for extension of corporate life are not to be given a liberal interpretation. So this came from another SEC opinion dated July 7, 1987. On to our 18th doctrine, which is the doctrine of ratification, which is fairly simple. As a general rule, the acts of the corporate officers within the scope of their authority are binding on the corporation. But when their acts exceed their authority, their actions cannot bind the corporation unless it has ratified such acts or is stopped from disclaiming these acts. Number 19. Our 19th doctrine is the doctrine of indivisibility of subscription, where it says that a subscription is one entire and indivisible whole contract. It cannot be divided into portions, so that a stockholder shall not be entitled to a certificate of stock until he has remitted the full payment of his subscription, together with any interests and expenses, if any is due. All partial payment, or other payments on one subscription, shall be deemed applied proportionately among the number of shares. The 20th doctrine is the doctrine of isolated transaction. It says that a foreign corporation can sue on a transaction or series of transactions set apart from the common business of a foreign enterprise, in the sense that there is no intention to engage in a progressive suit of the purpose and object of the business transaction. The next doctrine is the doctrine of equality of shares. Under this doctrine, each share shall be equal in all respects to every other share except as otherwise provided in the Articles of Incorporation and in the Certificate of Stocks. And you will find basis for this in Section 6 of the Revised Corporation Code, where the Articles of Incorporation does not provide for any distinction of the shares of stock. All shares issued by the corporation are presumed to be equal and enjoy the same rights and privileges, and are also subject to the same liabilities. Doctrine number 22, which is the special fact doctrine. The special fact doctrine states that a corporate officer with a superior knowledge gained by virtue of being an insider owes a fiduciary duty to the shareholder in transactions involving transfer of stocks. It is applicable when 1. The material fact or information was peculiarly within the knowledge of one party, and 2. The information was not such that could have been discovered by the other party through the exercise of ordinary intelligence. On to our number 23, which is the grandfather rule. The grandfather rule is a method by which the percentage of Filipino equity in a corporation engaged in nationalized and or partly nationalized areas of activities provided for under the Constitution and other nationalization laws is computed in cases where corporate shareholders are present, by attributing the nationality of the second or even subsequent tier of ownership to determine the nationality of the corporate shareholder. That is a mouthful. When I first read this, I actually did not understand it. So, like anything in law school, if I did not understand, I merely memorized. But eventually, I understood that this grandfather rule is only applicable when there are corporations holding stocks or shares of ownership in another corporation, especially if these corporations are foreign corporations holding shares of stocks in a apparently Filipino corporation engaged in nationalized or partly nationalized business. So when there is doubt about the Filipino equity or ownership of that particular corporation, the grandfather rule is applied. Okay, now we are on to the accomplished fact rule, which is our doctrine or rule number 25. It simply states that there are provisions of the Articles of Incorporation that cannot be amended because they are accomplished facts, such as the date of incorporation, because it cannot be changed, it is an accomplished fact, or the number of original incorporators, because they are original incorporators and you cannot have any more original after the original. So these are accomplished facts. Number 26 is the doctrine of centralized management, which basically says in Section 22 of the Revised Corporation Code, the board of directors or trustees shall exercise the corporate powers, conduct all business, and control all properties of the corporation. And down to the last two important ones. Doctrine number 27 is the ultra vires doctrine. It states under the Revised Corporation Code, Section 44, no corporation shall possess or exercise corporate powers other than those conferred by this code or by its articles of incorporation, and except as are necessary or incidental to the exercise of the powers so conferred. So in time, you will also get to understand which are necessary or incidental to the exercise of the powers so conferred in the Articles of Incorporation. And we're down to the 28th doctrine, which is actually the 27th. This is the Nell Doctrine, which states that the sale or transfer of the assets of one corporation to another does not ipso facto include the debts and liabilities of the transferor. Of course, there are exceptions to the Nell Doctrine, but I will leave it up to you to research the exceptions. So there you have it, ladies and gentlemen, all 27 doctrines, which I consider most important in the study of corporation law. But before I end, allow me to thank you for listening, and I hope you enjoyed the maiden issue of The Joy of Law. I'd like to invite you to make sure to smash that subscribe button down yonder and also the subscription bell so you'd be notified of succeeding episodes. You may also want to listen to my other podcasts in Spotify. You may look for Joy of Law.